Hello and welcome to the Rodgers Brief. I'm Adam Rodgers. Thank you for watching and thank you for listening. If you're catching this on Apple or Spotify podcast, I've been reading from Deficits of Trust, my ebook report on the events of the mass casualty in Nova Scotia of April 18th to 19th, 2020, and the Commission of Inquiry which analyzed those events. I'm in part 3 now, and I'm going to be reading today from sections 11 and 12 for sure, maybe section 13 of that section. Probably be another 3 videos, 2 at least, but probably 3 more videos to finish off the ebook report, and we'll get to the end of that, and it'll be saved as a playlist, if you haven't already noticed, on my YouTube page, and so people will be able to follow along that way. And then with the podcasts, you'll be able to almost treat it as though it's an ebook. So this is Unnecessary Accommodations for Senior RCMP Officers Leads to Participant Boycotts. This was not the only time the commissioner seemed to be willing or indeed inclined to sacrifice the MCC lawyers in order to preserve their own public reputations. They did so again when delivering a decision on witness accommodations that ended up generating a boycott of proceedings by many of the family participants. After operating out of 3 separate locations, most prominently the Nova Centre in Halifax, on day 26 of proceedings, the Mass Casualty Commission shifted their proceedings location to Truro. The decision appears to have been made primarily for scheduling purposes and in consideration of the availability of the Halifax venues. Truro is the closest major centre to the main events of the mass casualty and seemed as though it would have been the most logical initial choice for a location for the proceedings. The location can be very important. I saw firsthand how important it was to have the Desmond inquiry take place in Guysborough. That allowed family and community members more easily attend, and there is just something about being in a place that makes events sink in more deeply. Though it was further away for media attendees, many still came, plus there always remained live stream options available. The MCC proceedings should really have been held in Truro from the beginning. It is closer to the most affected areas, and so not only would have brought the commission team closer to the various scenes on a regular basis, but also would have provided a much better space for the community to better process the terrible events that took place. It is not only good to get people out of Halifax to gain some perspective, but also good to save people the hassle and sense of unease that can often accompany a trip to Halifax. That first trip to Truro seemed something like a token appearance, taking advantage of a scheduling conflict at the Nova Centre to tick a box on the trauma-informed checklist. The witness for May 25, 2022, Staff Sergeant Briers, did not come on shift until 7 a.m. on April 19, 2020, and was more in the background, not an operations commander. The next witness, Staff Sergeant Carroll, was the district commander for Colchester. While he certainly has a connection to the area and was central to much of the decision-making taking place, his testimony was conducted via Zoom, so he was not even physically present in Truro. So the location was not especially reflected in the choice of witnesses. Before even hearing from Staff Sergeant Briers, however, Patterson Law issued a statement that they had been instructed by their clients to boycott the following 4 days of proceedings. The statement indicated that they would not attend as they are disheartened and further traumatized by a decision from the commissioners, and that they will not be associated with this restricted fact-finding process for such critical evidence. These instructions arose as a result of a 7-page decision made by the commissioners with respect to accommodation requests by 6 police officers. 3 of these requests in particular caused concern, those being the requests for accommodations by Staff Sergeant Carroll, O'Brien, and Rahill, none of whom, it may be noted, were directly involved in any violent encounters, nor did they attend any scenes of violence. Staff Sergeant Carroll had asked to be questioned only by lawyers for the commission. That was rejected, though he was permitted to testify by video rather than in person. Staff Sergeants O'Brien and Rahill were questioned by recorded video, which was then posted to the MCC website the day after. Lawyers for the participants and the commissioners themselves were permitted to watch the interview, but had to turn their cameras off and could not ask questions. If the participants had any questions, they needed to submit them the Thursday before by 4 p.m. The witnesses then had 4 days over the weekend to prepare to answer. No medical information has been disclosed publicly to justify these requests, nor was any information provided that would even hint at the witnesses' difficulties. In their pre-testimony interviews, the staff sergeants did not describe any undue personal suffering or trauma arising from the events, so it is unclear exactly how valid their requests might have been when they were made. Given the previous accommodation requests we have seen from the National Police Federation and the lack of obvious trauma on display in the testimony following requests from officers whose requests were rejected, it is more than fair to question these new requests and the granting of them. There was no reaction at all to the boycott from the commissioners in their scripted introductory remarks. Chief Commissioner MacDonald repeated some of what was indicated in their decision about how accommodations are not meant to allow anyone to avoid testifying, but he did not so much as acknowledge that there was opposition to the requests. This fits with a pattern I noticed of the commissioners not wanting any video of moments of controversy in the MCC. If they were to explain their thinking in long form or acknowledge the boycott in their remarks, video of that could potentially make the news, and that seemed to be exactly what the MCC wanted to avoid. It was similar to the way they avoided the Big Stop video application from coming to a public hearing, which would have then created more video of an MCC controversy. Interestingly, in the decision itself, it seemed to me that the commissioners were again trying to subtly shift criticism of the MCC proceedings from themselves and on to the commission lawyers. The final paragraph of the accommodation decision noted that we rely on commission counsel to examine the masses of document disclosure, interview witnesses, and present the evidence in a fair and impartial manner to serve the public interest. In serving the public interest, commission counsel are instructed to engage in an objective and tenacious pursuit of the truth. In other words, they were saying, don't blame us. We can only work with what our lawyers provide to us. The problem with that is that in the interim report and their remarks on these accommodations, the commissioners reminded us that this is an inquisitorial process that they as commissioners control and direct. They were trying to have it both ways. The MCC proceedings did then operate from Truro for a few days. Outside of the facility where the proceedings were taking place, family members and supporters were protesting the Commission's decision-making on witness accommodation requests for RCMP supervisors. Those protesting were fully justified in their criticisms of the Commission's approach. The testimony being played inside provided a good demonstration of why the accommodation requests need not have been granted. Staff Sergeant Carroll testified for 3.5 hours in the morning, then another hour in the afternoon, with no unscheduled breaks being requested by him, and he displayed no obvious signs of discomfort nor certainly trauma. He displayed little emotion of any kind or much energy in his answers. The National Police Federation had requested accommodations previously for lower-ranking officers. These had been rejected, and the officers thereafter also testified with no obvious signs of discomfort or trauma. All of this served to undermine the credibility of both the NPF and the Commission. From doing personal injury work and especially conducting and observing long discoveries of alleged victims of injuries, I have learned to keep an eye on witnesses who make accommodation requests based on injuries or mental health concerns. If someone is complaining about a severe injury to their back or neck, but seems to be able to sit comfortably for hours at a time, that is noteworthy. Conversely, when representing a client who has such injuries, I would advise them to take breaks as needed, rather than trying to tough it out, which is usually an admirable quality, but which can be misleading or even damaging in such a context. The instinct, or at least effort, to protect these officers seemed to me totally misplaced. Testifying about difficult subjects or memories can have the effect of helping the witness process whatever trauma they are experiencing. We saw some of this from Staff Sergeant Briers, who had an opportunity to express his feelings of guilt at having missed what could have been key pieces of information while he was on shift. There are no findings of liability at this inquiry, and it seems to me a healthy exercise to allow people to talk about what happened in such an atmosphere. Staff Sergeant Carroll has many years of experience as an RCMP supervisor and was also trained as a crisis negotiator. He was scheduled to retire 1 month after the events of the mass casualty, and this seems to have affected how up-to-date he may have been with respect to communications and mapping technology used by the RCMP. He said he had not read any statements or materials since the mass casualty and had not listened to any police dispatches either in preparation for his testimony. He did not say why this was the case and was not asked by Commission lawyer Roger Burrell whether he has avoided reviewing any material because of concerns for his own trauma or mental health. Given his request for accommodation, this would have seemed to be a reasonable line of questioning and could have been asked without delving into the details of any treatment he might be receiving. It struck me that Staff Sergeant Carroll was very incurious about the events, and the brevity and vagueness of many of his answers seemed to also reflect this attitude. From watching the evidence of Staff Sergeant Carroll, I came to the same conclusions as I did watching that of Staff Sergeant Rahill. I came to the same conclusions as I did watching that of Staff Sergeant Carroll. There was no indication whatsoever that the officer was uncomfortable giving his evidence. He did not seek any breaks, or seem to display anything in his demeanor that would suggest he had been traumatized, was under treatment, or had any difficulty recounting events. The accommodations seem entirely to be a strategy developed by the National Police Federation and the Federal Department of Justice to protect the RCMP as an organization. One of the ways this chosen procedure protects the RCMP is that it is likely that hardly anyone watched these posted videos. I would be very curious to see the data comparing how many people watched these pre-recorded videos versus how many watched the live stream on a regular basis. Staff Sergeant Rahill was subjected to very gentle and leading questions by Mr. Burrell. For example, at one point he was asked whether he had any comment on the quality of mapping, or would you prefer not to answer that? As though it were at all a difficult question. Substantively, Staff Sergeant Rahill admitted that he could have followed up on his orders to Constable Grund regarding containment of the east side of Portapique, and that there were communications issues which could have been addressed. Though there were multiple staff sergeants giving orders, Staff Sergeant Rahill did not see that as a problem. He was glad to have the others helping out with their many years of experience. In lieu of cross-examination by lawyers for the parties, they were obligated to give any questions they might wish to have asked to Roger Burrell and have him ask them. It was not clear why having the same question asked by a lawyer for the commission as opposed to a lawyer for the participants would be less traumatic or more comfortable for the witness. If one were to think of how the questions could be less traumatic, you might imagine that having your own lawyer asking him would be the way to make the witness most comfortable. The commission lawyers are supposed to be tenacious in seeking the truth and uncovering facts, and yet the RCMP was evidently just as comfortable with them questioning their witnesses as they would have been with their own lawyers. Certainly, if other lawyers were given the opportunity to ask Staff Sergeant Rahill questions, they might have done such outrageous things such as politely disagree with his answers, press him for further details, or follow up in any way at all. Mr. Burrell did none of those things. In video, posted later that evening by the MCC, retired Sergeant Andy O'Brien testified about his role in the response to the mass casualty events. Sergeant O'Brien oversaw operations for the Colchester County RCMP, but was off duty on April 18, 2020, when he was contacted about the initial reports out of Portapique. He stated that he had 4 or 5 drinks of rum that night, and though he was initially reluctant to take on any role, he soon had a radio and was giving directions to officers on the scene from his home. The testimony was conducted by Zoom and was not broadcast live. There was also no cross-examination permitted, but rather the participants were again directed to provide questions to commission lawyers to ask, though as part of the boycott, most did not. This was the right approach for the participants, as it focused the pressure on the MCC lawyers to show that they could act in the public interest with their questioning. Nothing about Sergeant O'Brien's presentation or demeanor would convince a neutral observer that he required any accommodations. All of this just added to the lack of confidence that the participants and the public were feeling about the work of the Commission. In my view, it was incumbent upon the commissioners themselves to say something that would start to foster public confidence. As it stood, all we heard from the commissioners was when they would recite bland, pre-written welcoming remarks involving vaguely phrased statements about their mindfulness of everyone's trauma in all forms, or else when they, again in seemingly pre-written remarks, thanked witnesses for their difficult testimony, without any hint that the witness may possibly have been testifying about mistakes they made, for which it might be just that they suffer. In a criminal or civil trial, it is important for the judge to take some care in any remarks they might make, lest they open themselves up to allegations that they have predetermined the outcome in some way. In a trial setting, it is important to maintain neutrality. An inquiry setting is different, where there is a public engagement element to the process and public confidence is more of a live factor. In the Desmond inquiry, Judge Zimmer would ask questions of many of the witnesses, which would in part reveal to the participants and the public what he was thinking. In his questions, Judge Zimmer would show some insight and understanding of the evidence and would be working from his own notes, which he was making during the unfolding of the evidence. As a result, we were able to have confidence that he would not soft pedal or pull punches when it came to being critical of individuals or institutions. Here, we have no real sense of what the commissioners will do, and their interim report and interlocutory decisions on such things as accommodations and objections to evidence have not inspired confidence. Critical incident experts not permitted to criticize incident. Day 31 of proceedings was the second day in a row where the Mass Casualty Commission hosted experts from a wide range of locations to discuss proper police approaches to critical incidents. Unfortunately, as was the case the day prior, there was no discussion whatsoever of the events of the April 18th, 19th, 2020 mass casualty in Nova Scotia. There were two panel discussions on day 31. The first one in the morning dealt with issues around making decisions under stress. The afternoon session involved discussions on the societal context of policing, which included discussions on budgeting priorities, training, and use of force training. Krista Smith moderated the morning session, which also included Dr. Lawrence Allison from the University of Liverpool, University of Toronto psychology professor Dr. Judith Anderson, York Regional Police Superintendent Wallace Gosson, Dr. Matthew McAllister from Texas State University, and Dr. Neil Shortland from the University of Massachusetts Lowell. There would appear to be considerable study taking place on how stress can impact decision-making. The research and discussion can be summarized quite simply by stating that it is more difficult to make a good decision when a person is under stress, whether that be physical or mental stress, that nevertheless such decisions often must be made, and that therefore police officers should be self-aware of their own stress levels and, if at all possible, should take an extra moment before making crucial decisions. It is unlikely that any of that, or any of what was discussed in this panel, would strike any thoughtful person as insightful or unintuitive. The afternoon session was moderated by Dr. Emma Cunliffe and included Dr. Anderson, Dr. Paula Denota from the Heart Lab at UTM, Dr. Benjamin Gould from the Allard School of Law at UBC, Dr. Kimmo Himberg from the Police University College in Finland, Dr. L. Jones from Mount St. Vincent, and Dr. Hunter Martindale from Texas State University. Dr. Jones, the only local representative who was present for either panel, was the only person over the past 2 days to even mention the mass casualty, which she did in her introduction. Dr. Jones later spoke about her work with the Halifax Board of Police Commissioners subcommittee report, which recommended defunding the police. This was a report which I suspect many people dismissed due to its incendiary language around defunding the police, but which was compelling in its recommendations on police reform once you get past the title call. In civil and criminal trials, Experts are brought in to discuss some element of the fact scenario under examination and then to give their opinion on things within their field of expertise. The MCC approach was different. Here, there was no connection between the expertise and the actual events of the mass casualty. This is less helpful for the commissioners, as they will now have to shoulder the task of making those connections. This procedural choice also served to protect the police in the public eye. There were no headlines the next day of such and such an expert being critical of the RCMP response to the mass casualty, but only because nobody was asked the question. The choice of procedure was deliberate, and the experts were all told not to discuss any elements of the mass casualty. The commissioners did not explain why such a choice was made, but one of the primary effects was to spare the police some further terrible headlines. It was also ironic for the panelists to be discussing the problems associated with making decisions without enough time and without key information, all while the MCC was wasting valuable time on these theoretical critical incident discussions rather than digging into the evidence, all while facing a November deadline by which they were to make big decisions and file their final report. Now that the final report deadline has been extended by the provincial and federal governments, that time pressure is eased considerably. Dr. Himberg talked about decision avoidance as being cognitively lazy, which would seem to accurately describe the decision to fill proceeding time with vaguely relevant discussions rather than digging into the details of what happened and having experts testify about what they think of the actual events. Prior to proceedings starting that morning, there was an interesting story published by CTV News about the ongoing boycott by participants, which I thought could result in a pathway to ending the boycott. In the article, one of the lawyers for the participants, Tara Miller, noted that she is going to make an application to the MCC on her client's behalf to ask the commissioners to amend the rules of procedure. The amendment would be to Section 52 of the rules discussed earlier, which dealt with questions to witnesses. It stated, in part, that participants may have an opportunity to question the witnesses to the extent of their interest as determined by the commissioners. The proposed amendment would have changed that may to shall. Even with the change, there would still have been discretion for the commissioners to limit questions based on the degree of interest of the party. And they could also limit the scope and manner of questioning based on their discretion. The last restriction would be applied only to ensure that questions are relevant, scope, and that the questions are not being asked in a hectoring or otherwise uncivil manner. Having set the rules in the first place, it seemed unlikely that the commissioners would then amend them, particularly since they could have been allowing regular cross-examination under the existing version of Rule 52 had they chosen to do so. What an application would do, however, is bring the cross-examination boycott issue to the forefront and on the record. The commissioner's decision on the application was released late on a Friday afternoon, which in itself tells you much of what you need to know. The commissioners rejected the request from participants to amend the rules of procedure to enshrine cross-examination as a right for the parties rather than leaving it to the discretion of the commissioners. I was not surprised by this decision. Certainly the commissioners would not want to give up their discretion to control the process at the MCC. The true complaint is their exercise of that discretion, by which they have severely limited cross-examination and forced parties into the unusual procedure of collaborating on questioning of witnesses. The commissioners noted that the rules were distributed a year prior and nobody objected to the provision at that time. They also said, with respect to the staff sergeants who were questioned by recorded video without cross-examination, that the procedure worked as intended and that the accommodations were therefore appropriate. Neither of these justifications are all that persuasive, particularly for those who watched the testimony. Certainly, nobody could have expected the commissioners to use their discretion to limit questions as extensively as they have done. And just because witnesses conveyed information with significant accommodations does not mean they could not have done so without them. Given the commissioners' refusal to grant the application, the only other option for changing the rules would have been for the provincial and federal cabinets to jointly amend the orders in council, which formed the MCC and which, very loosely at times, guided their work. Since the critical comments from Premier Houston and Minister Fraser on the first day of proceedings, however, there have been no comments on the MCC proceedings from anyone from either the provincial or federal cabinets on the criticisms facing the MCC. After a week of dramatic testimony from senior RCMP officers and revelations which made national news, discussed earlier in this report, the MCC was looking to be much quieter as the month of June ended. Day 41 of proceedings featured a 7-person roundtable discussion on the mental health needs of families and communities after a mass casualty incident. A few days later, there was a similar discussion focused on the needs of first responders after a mass casualty. Part of the mandate for the Commission is to examine issues around supports offered to the families of victims, affected citizens, police personnel, and the community. That means that there is a requirement to try to understand what supports might have been seen to be effective in other cases and to compare them to what happened in Nova Scotia following the shootings. Like with other areas that were to be studied, the MCC took that requirement and adopted a very and perhaps overly thorough approach. Despite this thorough approach, none of the actual family members were invited to speak of their experiences of needing or utilizing supports. In fact, there was still no discussion of the specific events of the mass casualty of April 18th, 19th, 2020 in Nova Scotia. Instead, the discussion, which lasted nearly 5 hours, was a broadly based one which brought in other examples of tragedies in other places, such as Norway, the 9/11 attacks in New York, the Swiss Air crash off the coast of Nova Scotia. The discussion was led by Dr. Emma Cunliffe, the Research and Policy Director for the MCC. There were 7 panelists, or rather roundtable participants, for the discussion. They were Greta Dibb from the University of Oslo, Levant Alton from Victim Support Europe, Mary Fetchett from Voices Center for Resilience, a 9/11 support group, Great Village resident and former Northern Zone Grief Coordinator Serena Lewis, Megan McKelleran from Wayfound Mental Health Group, Terry Mitchell from Wilfrid Laurier University, and University of New York Associate Professor Jacqueline Schildkraut. The introduction portion of the discussion took half an hour to complete. The disconnect between the expertise being offered and the actual events being analyzed detracted from the usefulness of the discussion. There were discussions on dealing with families, information sharing, media coverage, how support systems should be in place prior to the crisis, and other topics that are relevant to the mass shooting, yet it was left for all of us non-experts, which would include the commissioners, to make the relevant linkages to the events being studied. It would have been more helpful to have these experts comment on what actually happened. As it was, we were treated to a seminar on the language of trauma and grief. There were many acknowledgments, references to resiliency, and we learned that physical conditions worsening after mental trauma is a version of somatization, without a sense that there is a real answer to the question of how to effectively deal with the mental outcomes of a traumatic event. Some of the lessons include relationships being important, people needing to be able to express their grief and rage, and the need to create spaces for that to happen. Things will never go back to how they were, and that systems should be in place to deal with the crisis prior to that crisis. Lessons from Norway and 9/11 include the reality that grief lasts a long time. Studies show that after 10 or 15 years in those cases that grief was still strongly felt. These realities and the general tenor of the discussion seem to be that nothing really works in the sense that it removes the grief or anger from the life of the survivor. One part of the grieving process is for people involved to see that something positive emerges from the tragedy, and lessons are honestly learned and needed changes made to systemic failures that may have contributed. In other words, the most trauma-informed thing the MCC could do for those grieving was to conduct a thorough and open review of what happened and make meaningful and intelligent recommendations. As part of their continuing effort to reduce the size of their viewing audience, Day 43 of the Mass Casualty Commission proceedings featured a further roundtable discussion. This one was focused on rurality and community well-being. The information on the MCC website suggested that the goal of the discussion was to address culture and attitudes of rural life in Nova Scotia, limited and differential service delivery in rural areas, and health and safety of those working in rural communities and how the rural context affects their working lives. The roundtable is facilitated by Dr. Cunliffe and was featured Robin Campbell, PhD candidate at Dalhousie University, Madonna Doucette, Director of the Youth Project, Dr. Karen Foster, Associate Professor of Sociology in the Department of Sociology and Social Anthropology at Dalhousie University, Dr. Leslie Frank, Professor at Acadia University, and Dr. Marilyn McDonald, Professor at Dalhousie University's School of Nursing. Dr. Cunliffe and the research team seem to be fascinated by these academic discussions, but they are only marginally connected to the events of the mass casualty. It is difficult to understand what the MCC commissioners think they are getting from these discussions, particularly considering the time and resources being expended in having expert reports prepared and then scheduling days and days of hearing time to listen to them. During that panel, for example, significant chunks of the conversation dealt with modern gender identity issues in Mi'kmaq communities, food insecurity, and the dynamics of child poverty. Certainly, these are important issues requiring serious responses, but none have anything to do with why a denturist was able to assemble a mock police cruiser, acquire and amass illegal weapons, and evade police capture on a 13-hour killing spree. Eventually, the commissioners will need to write a report containing advice on what governments and others should do in response to what happened in the mass shooting. To seek expert help in writing such a report is natural and sensible, but you would expect the experts to actually engage in the material you were studying in order to be of assistance. Here, the experts were not asked anything about Portapique or the incidents of April 18th, 19th, 2020 mass casualty. It all suggests that the eventual report is likely to include a series of broad statements on the issues being studied without commentary or insight on the specific events that prompted the commission to be called in the first place. All right, that's where we're going to end it for today. Those were two sections, two fairly long sections. We'll get back and start the next section, which is called Lisa Banfield answers no real questions, avoids criminal charges. So we'll get back to that in a few days' time. And in the meantime, thank you everybody for watching. Thank you for listening, and we'll see you next time.